Welcome back to the New England Take on WKXL 1450 AM, 103.9 FM, and NHTalkRadio.com. I'm AJ Kierstead, host of the New England Take, and we're joined today by Professor Buzz Scherr of the University of New Hampshire, Franklin Pierce School of Law, and we just had a great conversation about his backstory, being a public defender, overcoming shyness, and really learning to love the realm of public service and influencing people or really helping people that can't help themselves in the realm of law, and then making sure there's the next generation of public service attorneys. Because I'd imagine a lot of students don't necessarily think of being a public defender or working in public interest upon just entering law school. I mean, the money is not there.
Yeah, that's true. I mean, even when my wife and I were both working as public defenders, we made a total of $27,000, which those were 1980s dollars, but still, that's not a
Still
lot of
not a
money.
lot.
Right. So, moving to the law school was, and stumbling into that job, the job just opened up. I happened to be working as the deputy appellate defender, which was then housed at the law school. And so I had interaction with some students, and I had done a lot of training for the public defender program as I became a more senior lawyer. And I enjoyed it immensely. But I never really thought about being a law professor. Remember, I went to law school, so I didn't have to teach.
Yeah.
Um, um, but there the job was, and it was in areas, it was in teaching teaching evidence, running the trial advocacy program, and basically being a resource for students who wanted to be public defenders or public interest lawyers. And, there's quote unquote, two kinds of people in the world. There's two kinds of people who go to law school. This is a gross simplification, but some people go to law school with the instinct to help people. It may be helping working class people. It may be helping people on the margins. It may be helping minority populations. But it may be in a small rural law firm helping the community. And then the other group of people go to law school because they want to increase their earning power. It's not the exclusive reason they go, but it's the primary reason they go, and both are very legitimate reasons to go to law school. I was in the former category. I was kind of a To Kill a Mockingbird lawyer, so to speak. That's what that was my vision of helping. The law school job I have, being a professor, is the best. It's just as good as being a public defender. I get to help students learn how to learn well, because I'm not going to teach them all they need to know when they get out and practice. I need to teach them, more than anything, how to learn stuff when they get out and practice.
Yeah, I mean, there's a big difference between what someone who has a JD is expected to consider and be able to review and research than people that do other fields. It's totally different. I couldn't imagine doing it. I mean, I've been there this long. Multiple people have said, why haven't you gone to get a JD? It's like, my brain doesn't work that way.
Well, we're still working on you, AJ. We're still working on you. But, you get paid for solving hard problems, for using your expert knowledge to solve complex legal problems. And that's a very sophisticated skill. You have to have not only command of your expert knowledge and understand it, but you got to be able to, when you get in an area that's a gray area, you got to be able to investigate the nuances of your expert knowledge. So you need that kind of research analytical skill. But then you got to be able to have a set of social skills to work with your client to understand the depth of the practical problem they confront, work with the facts, so to speak, as we lawyers talk. And then you got to figure out, all right, what's the right body of law? What's the right area of expert knowledge to apply to this complicated problem? And use your judgment. I mean, lawyers in the end get paid for judgment, the exercise of their judgment in gray areas. Practically speaking, you don't, generally speaking, make a lot of money as a lawyer if you're good at solving easy problems.
Yeah, I mean, people don't. I mean, there's a kind of a reason why there's a financial barrier, there's a knowledge barrier. I mean, there's a lot of things you need to consider as a lawyer that you wouldn't necessarily think of. There's a lot of laws that maybe you don't know about that you need to work around or go
Yep.
work through in order to make things happen.
Yeah, your body of expert knowledge to start solving problems, which is half of solving problems and only half, is huge. It's not like, okay, I'll just go in the book and look up the answer. I mean, it would, if that's all lawyers did, they wouldn't get paid what they got paid, because it's not, anybody can do that. It's easy to train people to do that. You gotta take this body of expert knowledge and this body of expert knowledge and this body of expert knowledge, one of which you know really well, others you're not that familiar with. And any of those 3 or 4 or 5 different bodies of expert knowledge, in them, you may find the solution to the messy little problem that your client presents to you. So it's intellectually, for me, it's a thrill every day to solve legal problems in the area of criminal law that I work in and trial law that I work in. But you also need, the other half is you need social skills. You need to form a relationship with your client so you can mine your client for the information, and you can counsel your client to make good decisions, because many of the decisions that are going to be made in solving a legal problem are your client's decisions. You can make recommendations, but it's up to the client to make a decision. And part of your job is to,
whether it's the quote right decision or not.
Right. And you wanna help them improve their decision making in a very, very unfamiliar way, unfamiliar area. Like my experience was with criminal defendants who got a plea offer, on a first degree assault or on a homicide case. And the question was, what are our chances of winning at trial? If we lose at trial, what sentence would we get? That's the one side of the equation. On the other side of the equation, well, the plea offer is for X amount of years in prison. Tell me, Buzz, my client says, tell me, Buzz, what would you do? And my first answer to them is, particularly if a jail sentence is involved, is, I'm not the one going to jail.
Exactly.
It's your life, and you got to make the decision. I can give you my judgment. Trials are always risky. I have a good sense of who this judge is. I predict, quote unquote, that if you are convicted, even though we're going to do all we can to win, if you are convicted, I don't know. This plea offer, it's a close call. So, part of the discussion ends up very quickly becoming, so what's your life? Am I talking about a plea offer on a felony? Well, you're due 6 months in jail, and you won't lose your job, and your family can survive without you for 6 months? Or am I talking about a person who it gets an offer of a month in jail, who will lose their job, and their family that depends on them will have no resources, and they'll be screwed? And that's just on a not silly, but it's on a misdemeanor, a lesser offense. Deciding what to do in that circumstance, whether to take a plea offer, is much more dependent on the state of your life and your hope for the future, if you have any left, depending on where you are in the criminal legal system. It's a very complicated process, using your emotional intelligence and your social skills to work with your client to help him or her become a good enough decision maker in the context of the case to make a decision that fits their life. It's some of my best moments of as a public defender were when my client made a really good decision to take a plea offer. Some of my best moments are not winning case. I mean, God knows I love to win. I'm very competitive and go to trial and win. But I tell you, some of the best moments are winning cases by getting my client to make a decision that was good for them in terms of taking a plea offer. That's what moved me most deeply about being a public defender. And that kind of just a transition, that's what public service is about to me.
Yeah, I mean, this seems like a perfect transition to your work, working with government and lawmakers to enable these people that, just everyone. It's not even just people in low-income situations that would need a public defender. It's the general population as a whole that doesn't really have the time or expertise to know what it takes to make government change or government work in a way that supports them in their best interests. I mean, politically, we disagree on a lot of things when it comes to high-end policy, especially, I'd imagine, foreign policy and federal policy.
Of course, I'm always right, AJ.
Well, yeah, of course. I mean, I'm the one that's wrong. I'm aware. But when it comes to very libertarian, the government should be there to help you as opposed to control you view, it's something we agree on. And your work in privacy especially really stands out to me as something we definitely agree on.
Very much so. I got into the privacy realm. I mean, it was always there when I was a public defender. The Fourth Amendment is a privacy amendment. The government shall not engage in unreasonable searches and seizures. The Fifth Amendment, right against self-incrimination, is a privacy amendment. You cannot be forced to incriminate yourself. That's a statement about, your personal thoughts are private. The government can't extract them from you forcefully in any way. And there's certainly other kinds of privacy under Roe versus Wade, decisional privacy, the privacy to make personal private decisions without the government interfering. But once I stopped being a public defender, one of my areas of expertise as a public defender was in forensic DNA evidence. I did a lot of work. I was one of the first lawyers in New Hampshire from the defense side.
Your career kind of coincided with when that started blowing up.
Very much so, early 90s. And after I started to law school, I started working with a philosopher at Dartmouth and a geneticist at Dartmouth. And the three of us put together a program to train undergraduate faculty from around the country in 2-week hits during the summer, either in Hanover or in Washington, D.C., on genetics, law, and ethics. So I expanded my criminal justice privacy focus much beyond that to more broadly genetic privacy, which is a huge area and ever expanding. I mean, it's all over the place now. Privacy in terms of 23andMe or Ancestry.com, in terms of genetic genealogical websites.
And your literal privacy is everywhere because you're using your fingerprint on everything. You're breathing on everything.
You're shedding your DNA as you make your way through your daily public life. Do you retain any privacy when you go out? And can the police just follow you around and collect your DNA when you spit on the sidewalk or drop a cigarette butt on the sidewalk? So that really expanded my interest in privacy. And then in the early part of the 21st century, I joined the ACLU of New Hampshire, and pretty shortly after that became a member of the National Board of Directors of the ACLU. I was on that board for 6.5 years, and I was the president of the New Hampshire ACLU for about 6 years. And the ACLU is very, very focused, among many other things, on privacy issues. So that kind of got me going even more. Once I stopped being on the national board and being the president of the New Hampshire ACLU, I started working in the legislature, cooperating with the ACLU in writing privacy legislation. And as well as other legislation, criminal justice reform legislation. I wrote the comprehensive bail reform that was passed 3 or 4 years ago. I've done a lot of work in other areas of criminal justice reform.
I'd imagine lawmakers, especially on the state level, really value input from people with JDs and attorneys, because unlike on the federal level, where a lot of them have a JD or are lawyers, a lot of state level people aren't.
Yeah, and even more, at the federal level, Congress people have a staff of it, depending on the congressperson and their status. They have a staff of 5 to 10 to 15 people, depending, who are JDs, who have master's degrees in public policy or PhDs, and they do much of the writing of legislation that they're Congress people. And congressmen, can call somebody up and say, call me up and say, hey, Buzz, what about, what about this area? What should we do in this area? Give me some recommendations. And then a professor could work with their staff to write something. But at the New Hampshire level, they don't know, none of them have any staff. They get paid $100 a year. And they do yeoman work in the legislature. So very often they're very receptive to help in writing legislation. And sometimes they'll reach out to me on criminal justice reform. Sometimes I'll reach out to them with an idea I had. So I'll tell you a story that kind of captures this. I'd been working with a very conservative New Hampshire legislature on some privacy aspects of bills that he was sponsoring. Former Representative Neil Kirk from the Ware area, and he was very conservative, particularly fiscally conservative. But he was a libertarian in terms of privacy. He's a privacy nut, just like me. So we started working together on stuff. And I remember one Friday afternoon, we talked about a bunch of bills he was working on, and I suggested some changes. And he says, all right, I got one more thing. And he opens his right-hand drawer and pulls out this piece of paper and says, I've been trying to get a constitutional amendment on privacy passed in New Hampshire for the last 10 or 15 years. And I've never got it through even one house of the legislature. To get a constitutional amendment passed in New Hampshire, you need to get a 3/5 vote supporting it in the House of Representatives, 3/5 in the state Senate. It then goes on the state ballot, the next ballot, statewide ballot, and you need 2/3 of the voting public, the people who vote on it. And
very
then
hard.
Very hard. Yeah.
Essentially.
Then it becomes a constitutional amendment. So he said, so I want you to just rewrite this and make it so we can get it passed. So I did. I wrote it. It ended up saying, I'm trying to remember. See, I never can quite remember it, but it said the right to be free of governmental interference on your personal or private information is natural, essential, and inherent. Right? There is no mention prior to this, the writing of this amendment. When I wrote it, there's no mention of privacy at all in either the New Hampshire Constitution or the federal Constitution, the U.S. Constitution. So it goes in front of the House of Representatives. It gets 3/5 vote plus one. So it sneaks by in the House of Representatives. And I testified in front of the relevant committee. Then it goes to the Senate, and it gets exactly 3/5 vote. No more. It couldn't lose one more vote. Interestingly, in the Senate, one Democrat voted for it and all the Republicans voted for it.
Wow.
So it goes on the ballot in the November 2018 election. Hopefully, AJ, you voted for it. I think you would. Did. You would have liked the sound of it. So it gets 81% of the voting public. And it is now New Hampshire's latest constitutional amendment, and it's a information privacy amendment. Very powerful thing that we did. The backstory, the rest of the story is better than anything in many ways. December 31st of 2018, the amendment was the subject of a Jeopardy question.
You made it. That means you made it, right?
Right.
You can either be in a textbook or on Jeopardy, either one.
Well, I do surveys of my colleague, or when I got giving talks on genetic privacy or other privacy things, I said, so what's a more significant achievement, writing a constitutional amendment or doing what you did, be the subject of a Jeopardy question? It runs about two-thirds to one-third Jeopardy, in favor of the jeopardy being the more significant. But that, I continue to do criminal justice reform. We've got a facial recognition bill that just made it through the House of Representatives, and now it moves on to the Senate. We continue to work, sometimes successfully, sometimes not successfully, on privacy legislation, and for that matter, criminal justice reform.
Now, I just want to briefly just stick on the privacy amendment, because we got like 8 minutes left. So it's what's really fascinating to me about the privacy amendment is how short it is. An individual's right to live free from government intrusion in private or personal information is natural, essential, and inherent. That could not be more to the point. It reminds me of the Bill of Rights, where it's just, this is what it means. It still leaves room for people to interpret over time what exactly that means. I mean, at the moment, the first thing people think of is social media. They think of their email. They think of their phone calls. But in another 10 to 20 years, we can't even fathom what sort of ways. I mean, you're going to get the Elon Musk chip in the back of your head here coming up.
So well, I've been vaccinated. I'm fully vaccinated.
You got the Bill Gates chip.
I may well have the Bill Gates chip in me already. Well, it's an interesting point you bring up, because it's hard to write good legislation. And it's even harder to write legislation that is a constitutional amendment that's going to get voted on. Because, being able to do that, you got to decide what to make clear and what to leave to be determined by the court system. What counts as information? Does information just count as written stuff? Or is facial recognition, the points that a facial recognition technology extracts from a picture? They extract, data points from a picture, and basically, they create a frame around the picture and log in what that data tells you. There's an argument certainly that facial recognition technology is based on information. Now, is your face, as it's represented in public, private or personal?
As a photographer, it depends.
Yeah, and the amendment only applies to the government's intrusion.
Yeah.
So that's an interesting question, that whether or not the facial recognition statute that we've drafted and is making its way to the state Senate gets passed. That's an interesting question under Part 1, Article 2B. That's the privacy amendment, constitutional amendment. There's all sorts of things, and it was written not to nail down every possible problem, as you put it. It was written to be the statement of a core principle, a foundational principle that will be useful going forward in circumstances we're not even imagining.
Have there been any ways since it's gone through that have surprised you how it's been utilized?
Not yet. It's still early. Lawyers are just kind of remembering it's still there. I mean, in New Hampshire, we have the New Hampshire equivalent of the Fourth Amendment. It's called Part 1, Article 19, which basically is like the Fourth Amendment. But and so we've tried to squeeze 21st century information technology as acquired by the government into how the Fourth Amendment has been interpreted for the last 200 years. And it's gotten, particularly with 21st century information technology, the Fourth Amendment has gotten really, really clunky. But people are used to dealing with it in the context of the Fourth Amendment. So they're just getting started using the Part 1, Article 2B, the Information Privacy Amendment. But it's my revenge on the government. Even after I die, I will have an influence. So I can't overstate how satisfying it was to be a part of the process of getting that, writing it and getting it passed.
Have you seen any other states kind of pick up similar legislation based off of this?
Not yet. There's some states that had kind of privacy legislation, constitutional amendments, but not as explicit as this one and not as simple as this one. It's hard federally and in the state level. It's really hard to get privacy, any amendment passed, and any constitutional amendment passed, and the information technology companies which dominate our life, they have a lot of money to pay lobbyists. So that's a factor. It's easier to get privacy legislation, a statute written that targets a very particular area, like facial recognition. You got a better chance of getting the statute passed and picking off privacy protections at the statute level rather than at the constitutional level. And that's what much of the wave of privacy legislation over the last 10, 15 years has happened at the statutory level rather than at the constitutional amendment level. But New Hampshire's a leader. I mean, New Hampshire's always been deeply focused on privacy. There is a deeply etched libertarian strain in New Hampshire. And so, we were able to capitalize on that to get the constitutional amendment passed.
Give me the 2-minute elevator speech for your program at the law school.
Crime has become more and more international, and you need to, prosecutors and defense lawyers and people who work in government agencies need to understand transnational crime, cybercrime, human trafficking, international white-collar crime, piracy and terrorism. Those are all transnational crime. And we have the only master's program, an LLM program in the United States on transnational crime. And it's offered online, completely asynchronously online. And it's the only criminal justice master's program that any law school offers in the United States. So it's a cutting edge program in the area of transnational crime, wonderful for police officers, people who work in government agencies, prosecutors, defense lawyers.
Definitely check that out, law.unh.edu. You can learn more about the University of New Hampshire Franklin Pierce School of Law. The Franklin Pierce School of Law is integrated with the University of New Hampshire just a few years ago, so people don't necessarily realize there's been a law school in Central Concord for the last 40 years now. So please definitely check that out. Thank you so much, Buzz, for joining me today. This the second episode. I feel like it was a perfect way to kind of start going into the realm of public policy and things like that.
Well, maybe we can do this again later, and we can just fight instead of get along.
We'll get into politics. Don't you worry.
All right.
Thanks, Buzz. You're listening to the New England Take on WKXL 1450 AM, 103.9 FM, and NHTalkRadio.com. We'll be back in a minute to wrap up.